Welcome back. Mr. Etiaba, Senior Advocate of Nigeria, joins us this morning. Good morning, and thank you for coming on today.
Thank you, Chamberlain. Thank you, Nigerians and viewers.
Yeah, what a weekend.
Good morning.
Good morning. What a weekend it is, actually, because quite a number of judgments that came through, and several people just looking to see, for instance, just this particular one, which affects a lot of things, is this cash one that happened Friday. And then already this morning, many waking up to see the dailies reflected, and rightly so, how there isn't any compliance in the marketplaces, in the banks, different perspectives. Banks saying, well, they wait on CBN probably waiting on directive from the president, and then you wonder, how should is that the way the process should be? First of all, let's start with you giving us your impression about how the judgment went. Did you see that eventually this was how it was going to be?
I did not see it come out this way because I had looked at the course of action, and I realized that the course of action was basically challenging the monetary policy of the CBN. And I sincerely believe that the Supreme Court was not the right venue. Yes, parties, Edo State and Bayelsa State challenged jurisdiction, but the Supreme Court felt otherwise, felt they had jurisdiction, and they indeed assumed jurisdiction. I believe that there was a course of action, but that course of action ought to have been commenced at the Federal High Court. Even if it was an emergency, by reference, the matter could have come to Supreme Court sooner than it would have gone if it was not referenced. But the Supreme Court assumed jurisdiction and went on to deliver its judgment. The Supreme Court judgment is final. You can only appeal to God. But again, the problem you're seeing now is the problem we identified when we said there's a jurisdictional issue, because Central Bank of Nigeria, who in the main came out with that policy, was not made a party in the suit. And so judgment has come. There's no direct directive on Central Bank on anything to do. The judgment is against the Federal Republic of Nigeria, And so it now behoves on the party that was sued to make sure that Central Bank complies with that particular judgment. These are the issues. And the people who came up with that suit knew that Central Bank ought to have been a party in it. And if they indeed made Central Bank a party in it, then it will be more obvious that Supreme Court does not have jurisdiction over the matter. I can also tell you that being a part of that suit, I was in court when Lagos State, apart from being part of the initial, the consolidated plaintiffs, co-plaintiffs in the main suit, they came up with a different suit. And in that different suit, you will see that Lagos State realized that there was a question of jurisdiction, and then they went ahead to now formulate a new case that had to do with Lagos State and federal government. So that is the problem you see playing out.
So what did they hope to achieve with that particular strategy?
No, they wanted the Supreme Court to now go ahead and treat their suit as a separate suit. But of course, the Supreme Court is bedeviled with quite a lot of cases. They don't. In fact, on the day the suit was had, the court made it obvious that they cannot begin to pick and choose which one to deal with, that they will deal with the main suit. And that is what I presume they did.
So when you say the CBN wasn't a party to the suit, they ought to have been made a party to make it more clear. But we also do remember that Mr. Fadana told us several times that, well, the CBN themselves have benefited from cases that they were not directly parties to, so they cannot pick and choose when to plead or make a point as to we not being party to the suit, having benefited from such scenario before.
The danger in listening to we lawyers is that we give you opinion based on where we stand. You cannot say because I have enjoyed a privilege or the largesse coming from a suit that I was not made a party, now when a suit that I'm not made a party comes, I must suffer for it. No, the law is straightforward. A principle of law is a principle of law.
What about precedents? Isn't this a precedent already by itself?
There's no precedent that says that if a judgment that does not have your name will bind you. There's no precedent like that. So when you talk about principles, you get it right. When you talk about if this happens, the other one will happen. No, you're not getting it right. And so, and that is why the law insists that law is what the court says it is, not what a legal practitioner says it is.
Okay, but right now, the court has said this is the position.
Yes.
Can CBN still claim not being party to the suit and not
the federal government has been directed, and by inference, its agencies. I'm not saying central bank should not obey. I'm telling you where the problem is coming from, where the issue is arising from. Now, the central bank will hide under federal government. If they were made a party ab initio, what the plaintiffs will do now is to go after the governor of central bank.
How long does it really take for bureaucracy to kick in? Because as you've said, by extension, I mean, if the federal government is the one in the suit and its agencies are covered under the umbrella of the federal government, how long should we expect that it would take for the bureaucracy to kick in and the central bank get the directive that it needs to do what it needs to do?
It takes for as long as the president of Nigeria decides to give the directive. Like when he included the 200 Naira note, old note. He didn't take anything. He just took a statement from him. So a statement from him, a directive to the central bank governor, will work the magic. It doesn't take 1 week, 2 weeks.
Okay. Well, we'll see how that eventually pans out. Because for a number, I think the Supreme Court also wanted the politics of it. Do you think that, I mean, he wanted the politics of it to die down? Because I remember that before they finally had this judgment, he talked about how the Supreme Court will not be the scapegoat of anybody. And there are big questions as to whether you think that sufficiently the politics of it, I mean, whether or not this was supposed to stop vote buying, this was not supposed to stop vote buying, that controversy, do you think that sufficiently it has died down for people to be able to see what, you know, the issues that have been raised on their merit?
I think the Supreme Court was smart enough because on the day the suit was heard, they were very, very specific and deliberate that Supreme Court and the courts will not be made scapegoat in this matter. And they indeed had everything the same day. In fact, for the processes that were not yet filed, but there was an indication that they will be filed or they are being filed, the court said, we will hear all of them. And they indeed had all of them and came up with their verdict. You know, so that's basically, I can tell you that Supreme Court did well in giving expeditious treatment to the matter. But my only issue, is still an issue for me, is appreciating that issue of jurisdiction. But they did well.
When we hear scapegoat, it comes across with different people differently. So could you, I mean, did you understand that you could shed light on that for us, if you will, when they say we will not be made scapegoat? Because everybody thought, Supreme Court, I mean, courts usually will attend to cases that are before them. So wherein did this mindset of scapegoatism come in?
Yes, it comes in because Supreme Court justices are human beings. They are Nigerians, and they have eyes, they hear, they read. Even if they wear their big wig and you don't see their ears, they hear. You know, so what has happened is that, for example, in this era of pre-election matters, quite a lot of political parties refuse to do the correct thing. And these matters are pushed to the courts. And so nobody now begins to look at what the political parties did wrong. What the people are looking at is how the matters were adjudicated by the Supreme Court and indeed courts. And they say, no, don't stop pushing these things to us and we'll now become the fall guys.
I thought they always say that the courts it doesn't matter what happens in the court of public opinion. They decide their cases based on what is before them.
But when you're talking about a political case, you don't shut yourself out from that. That is why a lot of people criticize their judgments. Have you seen people sit back and criticize judgments of the Supreme Court that are related to land matters, related to one corporation or the other? No, people don't do it because they are not topical issues. They don't affect the people and their expectations. So what they are interested in is that political one, where 1 + 1 in their eyes should be 2. And if it doesn't look like 2, then they begin to talk.
So, well, I know that I'm hoping that our colleagues in Lagos will be taking the conversation in that regard, or maybe they'll add whatever it is. But you do know that right now, quite a number of issues have now been raised as a result of the we just concluded presidential elections.
Yeah.
Talking about transmission of results, what that was supposed to mean, whether or not the FCT counts as a state, or whether it's a separate entity by itself that has to, a candidate has to fulfill 25% in the FCT as well. I'm wondering, first and foremost, let's take on the issue of the FCT. Some people say that the FCT in the Constitution, in terms of the requirement, I think it's section 137 or so. I'm not very convinced. I have to double check that. In terms of what the Constitution requires, that the FCT was meant to be treated as a separate entity. Others feel that no, the FCT is to be treated as a 37th state of the Federal Republic. I don't know, from your own reading, what do you make of that reading of the FCT's inclusion?
First of all, I'll tell you that whatever we're discussing and Nigerians are discussing on this issue can be said to just be some academic exercise, because the law is what the courts say they are.
It is.
So that is simple. But then I look at whether FCT is a state or is not a state. I don't think that is in dispute. Some people confuse themselves, saying that Section 299 arrogates the status of a state to FCT. But that is not correct. It is not correct, and I'll read it. It's not correct.
Yeah, I see that section 299.
Okay, section 299 reads, the provisions of this constitution shall apply to Federal Capital Territory, Abuja, as if it were one of the states of the Federation, as if it were. If it is one of the states, it won't be as if it were. And the constitution here is discussing the administration of FCT. And it says you have to look at it the way states are looked at. To put it beyond conjecture, if you look at Schedule 1, Section 3 of the same constitution, it lists the states in the Federation. FCT is not one. The states are enumerated one alphabetically from 1 to the end, from state number 1st to 36. And in law, it is beyond conjecture in law. It is trite in law. It is settled in law that when you have a list in a legislation, any other thing that is not within that list, which ordinarily you think should be on the list, if it is not there, it is excluded, totally excluded. So FCT is not one of the states, and it is totally excluded from the states by the Constitution, which is the ground norm. So people saying it's a state, it is not a state. Many judgments have come. The Constitution says in 299 that it should be administered as if it were a state. The language is very straightforward. So for people who are confusing this, they are doing it deliberately. I can also tell you, that's why I tell you that people give opinion from where they stand. That provision of Section 134,
134, yeah.
The 134, is straightforward. We can also read it. 134 is 134.2. 134.2 is also there for everybody to see. It says 134.2b says, talking about the candidate who will be declared the winner, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory. After talking about all the states, it makes an extra mention of FCT, Federal Capital Territory, Abuja, which means that there's something about FCT. I can also tell you that in the previous constitution, there was no mention of FCT because FCT was not in place then. When you talked about Shagari and and the UPN.
Lagos was the capital at the time.
Lagos was the capital at the time, and Lagos was a state. There was no need to mention it. But when there was now the 1999 Constitution, in the wisdom of the drafters of the Constitution, they added FCT. And somebody sits back and says, no, it does not matter. FCT is a state, or should be considered as a state. We are looking up to the courts to make the pronouncement. But what you see is people talking from their standpoint, where they stand. But I'll also tell you, and it's very important, whether FCT is to be considered as part of the 36 or not. What is not important now. What is important is that this has become a topical issue, and it's what we call a tribal issue. It is something that the court must resolve. It has elevated itself in the public discourse, in legal discourse, as an issue that the Supreme Court must make a pronouncement on. So it is not easy for anybody to sit back in the comfort of his office and say it does not matter. The person is saying it does not matter because of where his political leaning is. But if you read it as it is, without adding or minusing, you know that there's something about FCT.
Let's go to Lagos.
Thanks, Chamberlain. Let me just follow up on that point, because a lot of people were looking to INEC to get some sort of clarity on that provision. But from what we saw, INEC declared the results, announced the results, declared a winner without speaking to that. And for some people, it was some sort of answer to the question saying, well, there was no need really to separate the FCT from that, you know, the whole 36 states of the Federation. So first, INEC had said, because I remember, I think Malpe was asking Mr. Okoye that, well, how will you approach this? And INEC said, well, we have senior advocates in INEC who would actually give us directive. And I imagine that this is the directive or the interpretation given to them. Was it INEC's responsibility really to also come out with a position? Or is it INEC's responsibility first to come out with a position? Because you've said the court, but INEC clearly sat with the SANs in its commission and sort of made a decision. So I don't know, did they have to go to the court to get some interpretation, or that was in order?
Oh, thank you very much. The truth is that what is at stake in that election is so much that it is not something you just sit and then you wield your power because you can wield it. Even at the Supreme Court, I use Supreme Court as an example. There are matters that come to Supreme Court, and the Supreme Court will say, oh, okay, I've had your own submissions, but we're inviting 2-3 lawyers to come and address us on what they think should be the position of the law, amicus curiae. And then these people come in without having any interest. They dissect the law, and then the Supreme Court will consider their submissions together with the submissions of the parties and come up with a decision. If Supreme Court can do it, why won't INEC do it? INEC has access to very senior lawyers. They also consult senior lawyers when they go for a defense of their results. So why would they not do it? And like I have issues concerning the election, and you see that deliberately again, INEC is doing what it's doing. Dr. Olisa Abakoba wrote a letter to INEC. It was widely circulated, where he pointed the attention of the commission to this issue of FCT. And to show you that he was very selfless in his letter, he said, I don't have the answer. So you guys go and figure it out before you do anything. Olisa Abakoba wrote that, and you know, in his character, he normally does things like this in the interest of justice and unity of the country, you know. And then what happened? They now came and made their return. It is not the only place where they made the return. It's not the only issue that they swept by under the carpet. The issue of the complaint of manipulations in the result sheets, beavers not being uploaded. The parties, their agents, made so much fuss about it. They were promised that the commission will look into it. Indeed, the section 65(1) of Electoral Act gives INEC 7 days to look into those issues before making a return. Did they do that? They did not do that. They just finished and right away. And they told everybody, if you're concerned, you go to court. Well, and you know there's this saying that if a wrongdoer does a thing that is wrong and tells you to go to court, it means that he's sure of what will come out of the court.
Well,
and it is very sad because we're talking about the votes of the people.
Right.
The votes, even by the declaration made by INEC, even by that declaration, you see that the person that was said to have won the election did not score up to 1/3 of the total votes cast, which means that there's something to be looked into.
If I can comment
the Labour Party says we won in in Rivers State, we won here. The votes that we were given in Lagos do not represent our votes. We have, and it's in video. And then you go to the places where PDP won. You see how their votes were also cut short. And they have these things in result sheets. And they say, please, you need to revisit this. And the law says you should revisit it. There was no compulsion in announcing the winner of the election. Indeed, Section 70 even gives the commission up to 14 days before making a return. It says you can make that return within 14 days.
Also, so if I could just come in.
What was the haste?
Right.
Why would people be crying and you think it doesn't matter?
Well, pardon me. I mean, some of the points you made, I recall that the INEC chairman, he had a meeting with the RECs across the state, and he said it again that, well, they have received petitions from political parties and I think even civil society, and he acknowledged those reports and said that they're being looked into, and where infractions can be established, there will be redress. Those were his words over the weekend. And I think now the debate is how do you decide whether INEC made the right choice in announcing the results? First, is there a law that says that he can stop it midway and says that he mustn't go ahead with it? Did he breach, or did the commission as a whole breach any law? Some have argued again that, well, perhaps maybe that decision didn't swing the way of some. That's why it is deemed to be, well, perhaps the wrong decision to have been made. But again, the point about the 1/3, the 25%, just to be clear, in what way should the Constitution have put it such that it will be clear enough for all to maybe understand? So we wouldn't have this debate, because going by the letter by Dr. Agbakoba, he didn't even ask INEC to go to court. He just asked INEC to give an answer to Nigeria. And so again, in that light, it would seem that INEC was in order to have done its consultation in-house, or whichever way it did it, and come to that conclusion.
Oh, yes. Of course, INEC may have done their consultation in-house and come up with a conclusion. But I am saying that those things were hasty. You know, Section 72 of the Electoral Act gives them 14 days within which to announce result. What was the haste? Okay, you're talking about their power to review. Yes, INEC has power to review. Even at this stage that they have declared a winner of the election, they still have time. The Section 65(1) gives them 7 days. So even after declaring Tinubu the winner, they still have 7 days to review it. So we're waiting. We're still within the 7 days. Maybe by end of work today, or they would call and say, no, we have a problem with that declaration.
Who's supposed to trigger it? That's Section 65.
The parties that are aggrieved, and I know they've made a representation to INEC.
Well, just one quick
so
question.
they're still within time.
Yeah.
You see, they're still within their 7 days. But what they couldn't do before they declared, I doubt whether they will still do it now. Because they've told anybody that cares to go to court.
Well, you already said it yourself.
And that's where we find ourselves.
Mr. Etiaba,
and that is really sad.
My apologies.
We saw, these days we're not talking about.
Yeah, just a second, Mr. Etiaba. I mean, you already said it that, I mean, we only need to wait for the authorities to do whatever it is that they need to do. But there's a question you raised, some conversation you had when, Malcolm was asking around the Naira policy and the Supreme Court ruling on that. Allow me to go there for just one bit. So if the CBN was not joined and the federal government was directly addressed in that judgment, how about the principle of vicarious liability? Doesn't that apply here?
We're talking about vicarious liability is that somebody's wrong. If somebody commits a wrong, you, the principal, can be held responsible. Oh yes, but you cannot visit it on this. A court order must bind the parties. Now, well, I'm not even saying that it doesn't bind CBN. That is not my take. My take is very simple. The people that formulated this case, they know they were proceeding against CBN, and they refused to make CBN a party in the suit, because if they made CBN a party, it will be more glaring that the Supreme Court does not have jurisdiction over the matter. Now, they made the federal government the party, and said, and their agencies. So you now present a case that will still need some interpretation to execute the judgment. There was no need for that. So what we now find is an issue around the way the plaintiffs crafted their reliefs and the parties to the suit. And I'm not saying that CBN shouldn't be bound by that judgment, but I'm talking about why these little issues are arising. When you know how to do things right, why do it the other way? You want to short-circuit the system. Why didn't you bring central bank into the suit ab initio?
But you also heard the Supreme Court justices.
Federal government can get CBN.
My apologies. You also heard in that judgment of the Supreme Court arguing to the defendants that, look, as far as the Supreme Court is concerned, the justices were concerned, that is the proper thing to do. The CBN shouldn't have been added shouldn't have been made a party to the case in the first place. And that's consequently, they made that decision, especially because the CBN cannot go on without the CBN and the president himself making a pronouncement according to the CBN Act of 2007.
I'm actually not in a position to sit on appeal over Supreme Court judgment, and that's why I'm not going into the merit. I can tell you that all Supreme Court does is good, but the truth about it is there are issues that are still unresolved, and they are revolving around that the formulation of the parties to the suit.
Well, I hope it doesn't affect the Naira this week, because people need Naira to spend. So at the end of the day, I think the markets just want this thing sorted once and for all. I know you need to run. By the way, couldn't CBN have just applied to join in this suit? We know we see that all the time.
If they had applied to join, the issue is very straightforward. They don't have the capacity to walk up to the Supreme Court and say, join me in a suit, because you can only be joined in a suit if ab initio you could have been a party. The Central Bank couldn't have been a party in this suit, so no person can join them.
Okay. Well, we just want this Naira out there, basically. So we'll hope to see how that happens today. It's a Monday, so I'm not sure there should be any further reason for this not to be resolved. We do thank you for coming on this morning, Mr. Etiaba, Senior Advocate of Nigeria. We will be back in just a moment. Stay with us.